Thanks, Don.
Madam Deputy President, I lead for the opposition and debate on the Crimes, Domestic and Personal Violence Amendment Review Bill 2016. The opposition does not oppose the bill but will seek to amend it by deleting the proposed change to section 101 capital J of the Coroners Act, which reduces reporting by the Domestic Violence Death Review Team. The object of the bill is to give effect to the recommendations contained in two statutory reviews. These are the Statutory Review of the Crimes, Domestic and Personal Violence Act 2007 and the Statutory Review of Chapter 9 capital A of the Coroners Act 2009, the Domestic Violence Death Review Team. The vast bulk of this bill relates to the former of those two reviews and involves amendments to the Principal Act, the Crimes, Domestic and Personal Violence Act. The review is dated 2015 but only became publicly available last week when the Attorney General tabled it in the other place. The majority of both the changes in the bill and the recommendations in the review are described by the review as procedural issues. In 2007, the Principal Act was introduced by the former Labor government. As the statutory review noted, and I quote, "It is a standalone legislative scheme that consolidated relevant provisions in one place, reduced the complexity identified by the New South Wales Law Reform Commission and strengthened protections for victims of domestic violence," unquote. There were further amendments in 2008 and under this government in 2013. The statutory review also noted at paragraph 2.14, and I quote, "In its 2014 evaluation of the current scheme, the Bureau of Crime Statistics and Research reported that 98% of women who experienced physical violence in the month to taking out an ADVO no longer experienced physical violence in the month after taking out the order. The study also showed that 24% of women had experienced stalking before an ADVO was taken out, compared to 3.7% after an order was made. The survey revealed that an overwhelming majority of women who take out ADVOs believe they are effective in deterring violent partners," unquote. This review is carried out by Justice Strategy and Policy within the Department of Justice, pursuant to Section 104 of the Act. It required a review to be undertaken within 3 years of assent to the Act, which was on 7 December 2007. The review made 17 recommendations. The bill adds extra offences from the Crimes Act to the definition of personal violence offence in Section 4 of the Principal Act. The review mentioned Sections 112 and 113 of the Crimes Act, but did not purport to provide an exhaustive list. The bill has a longer list of offences contained within it. The review talks of resolving anomalies by including extra offences. Following recommendation 4 of the review, the definition of domestic violence offence is expanded with the expanded provision contained in new Section 11. The definition of domestic violence, a domestic relationship, is extended to include a current partner and a former partner of a person. There is a useful case study from the review that explains the practical impact. Susan and Tom lived together in an intimate relationship for 7 years. After separating, Susan formed a relationship with James and has been living with James for 2 years. Recently, Tom has made violent threats against James. Under the current Act, if James wants the protection of an AVO, he needs to make his own application to the court for an APVO. This may require James to enter into mediation with Tom, for example, which is not a requirement under the ADVO scheme. Quite often, including matters within the apprehended domestic violence order scheme does not add a protection that is not already there, but is a much better way of getting that protection or getting the order. There is also a substantial change concerning the circumstances in which an ADVO can be issued. The Act presently allows the court to make an order without being satisfied that the person in need of protection in fact fears the defendant's conduct when the person in need of protection is a child, suffers from an appreciably below average general intelligence, or when there is a history of personal violence. The relevant conduct includes intimidation, stalking, or the commission of a personal violence offence. The bill adds a new category to this group, where an order can be made without the court being satisfied that the person in need of protection in fact fears those things. This new category means an order can be made if the court is satisfied that the person concerned has reasonable grounds to fear the commission of a domestic violence offence against the person. They are, however, limited to what are sometimes called the standard orders in Section 36. A number of procedural issues were recommended in the review and are found in the bill. The bill provides for the term of provisional orders and when they cease to have effect. There are provisions to allow the court to proceed to final orders in the absence of parties, which is modelled on a provision in the Criminal Procedure Act. Recommendation 6 of the review is seen in amendments to section 48 of the Principal Act concerning applications for orders to protect children, if only children are to be protected by the order. There are other amendments concerning the admission of evidence and transcripts from the Supreme Court and District Court, the replacement of section 72 concerning applications with the removal of a provision allowing final orders to be revoked after they have expired, and a number of other provisions that we don't need to go into at the moment. There are two other changes worthy of mention. Section 99 of the Principal Act deals with cost orders. It says that costs awards are governed by the Criminal Procedure Act. It then provides additional provisions. The bill proposes a completely redrafted section so that it is a standalone provision that sets out the provision regarding costs separate from other legislation, which I think is appropriate. New section 99A provides that costs cannot be awarded against an applicant unless satisfied that the application was frivolous or vexatious. Costs cannot be awarded against an applicant who is a police officer unless he or she made the application knowing it contained matter that was false or misleading in a material particular, or had deviated from the reasonable case management of the proceedings so significantly as to be inexcusable. This reflects recommendation 13 of the review. This redrafted provision is narrower than the existing section 99 because the Criminal Procedure Act set out wider circumstances in which costs could be ordered, including, for example, for procedural misconduct. These issues were considered in the case of Redmond v Wilkes in the Supreme Court, where the court said that the interplay between the Criminal Procedure Act and the Principal Act would benefit from clarification by the Parliament. The review records a rise in the number of cost orders against police since that case was determined. This new section will hopefully resolve that. New section 41A will prevent children who appear as witnesses in ADVO proceedings being questioned by a defendant directly. They will be able to be questioned only by a legal practitioner or a suitable person. One immediate problem that emerges from the review is that legal aid is generally not available to defend ADVO proceedings, and therefore wealthier defendants may get a benefit from this provision as opposed to other defendants. The solution is to not allow the defendant to personally cross-examine the witness, and the option of having another suitable person undertaking that task is, of course, another alternative. The Act already says that a child is required to give evidence in apprehended violence order proceedings only if the court considers it is in the interests of justice, and the court, in any event, must be closed. The Criminal Procedure Act means children can be accompanied by a support person. Children can also give evidence in chief through a recording or an audio-visual link. However, the Local Court Practice Note number 2 of 2012 domestic and personal violence proceedings already says that children cannot be questioned by an unrepresented defendant and may be questioned only by a court-appointed legal practitioner. Effectively, this bill moves that practice note into a statutory form and, of course, would extend it. Schedule 2 to the bill before the House provides amendments to the Coroner's Act and flows from the statutory review of Chapter 9A of the Coroner's Act 2009 on the Domestic Violence Death Review Team. Dated October 2015, this review was also conducted by Justice Strategy and Policy in the Department of Justice. Chapter 9A was legislated for in 2010 by the former Labor government and was recommended by the report of the Domestic Violence Homicide Advisory Panel. Section 101P of the Coroner's Act required a review of the chapter to be undertaken 3 years after the commencement of the chapter. A report was to be tabled within 12 months after that 3-year period, so this review is also late, although not as late as the ADVO review. This bill implements the review's recommendations concerning the definition of domestic relationships, the representation of various agencies and departments, and the inclusion of the Commissioner of Victims' Rights on the team. Recommendation 4 of the review recommends the inclusion of an additional Indigenous representative on the team. The bill doesn't quite achieve that, adding an extra Aboriginal person or a Torres Strait Islander if no other member of the team is already within that category. The bill also proposes an amendment to Section 101J of the Coroner's Act, reflecting recommendation 6 of the review, so that the Domestic Violence Death Review Team only reports every 2 years rather than the present yearly reporting. The Labor opposition does not support this particular proposal. We believe that annual reporting should continue, as was the case when the team was established. If domestic violence-related deaths are as serious an issue as we believe they are, it is not acceptable to reduce the frequency of the reporting requirement. And that is especially the case when the basis for making the proposal in the bill is so flimsy. I think we can all recognise that the issue of domestic violence and violence against women is a terrible scourge in our society, requiring the resolute action by all sides of politics and all levels of government, leading a wider societal discussion to change the underpinning attitudes that can give rise to these unacceptable behaviours.
No,
It is sending the wrong signal in that situation, in that context, to reduce the reporting requirements from 1 year annually to every 2 years. It just doesn't make any sense. While it's certainly a recommendation of the review, the consideration given to the issue in the review is cursory and we think quite thin. The only consideration is one paragraph of the review, paragraph 4.62 at page 27. The only suggestion for biennial reporting comes from the convener of the team, the State Coroner. The reasons cited in the review and ascribed to the Coroner we find unpersuasive. It sounds more like bureaucratic convenience rather than a sensible, reasoned proposal. The claim that it would somehow facilitate the increased interagency collaboration we also find unpersuasive. If anything, the opposite is the case. We think it could lead to drift and delay in the activities of different agencies. The real issue here is that the government does not take the work of the team seriously, we think. In 2014 there was a substantive hiatus in the work of the team. The government refused to appoint a convener so the team could not meet. This followed the resignation of Mary Jerram as State Coroner in November 2013. The end result of this approach by the state government is that year's annual report was delayed by about 15 months. The 2012-2013 report was tabled only on 20 March 2015, which is an extraordinary situation. And then there is the government's inadequacy in responding to the recommendation in the team's report. It's not just a failure to appoint a convener that reflected the government's disinterest. Inaugural team membership had expired in February 2013, but new members were not appointed by the government until November of that year. The Women's Legal Service of New South Wales also opposes the reduction in reporting, and it writes, and I quote, "We do not support the DVDRT preparing a report for Parliament only once every 2 years. We believe it is important that systemic issues are identified and made public in a timely manner, so improvements which could save lives can also be made in a timely manner. At a minimum, the DVDRT should report annually to Parliament, as is the current legislative requirement," unquote. Indeed, the letter points out that the New South Wales Women's Alliance had previously argued that the reporting should be every 6 months. That is twice as frequently as the law currently provides and 4 times more frequently than what this bill would propose. A previous member of that team has expressed concern about the proposed changes, pointing to the number of recommendations that have not been implemented, and that is more likely if the recommendations are not reported frequently. The lack of scrutiny that comes from more frequent reporting we think will give rise to lack of action. The lack of frequent reporting reduces scrutiny. The government is not using the knowledge that is coming out of these death reviews. The review concedes difficulties in implementation. It would seem to me that those difficulties would be made worse, not improved, by lengthening the time between reports. The opposition has also received a letter from Women's Legal Services New South Wales dated 10 May 2016, raising a number of issues which the opposition seeks a response from the attorney in her, and of course in this House from the Honourable Parliamentary Secretary. We understand that the letter from Women's Legal Services was also sent to the Attorney General. Women's Legal Services New South Wales seeks clarification that inclusion of Section 43 A of the Crimes Act in the Section 4 definition of personal violence would not be used as a tool to hold the adult victims of violence accountable for the perpetrator's violence and or failure to provide. It is concerned as to whether Sections 51 A, 53 and 54 of the Crimes Act can be included in the definition of the personal violence offence. It inquires as to whether the current wording in Section 16(2)(c) Roman 1 should be retained and not amended as proposed. It is concerned that the expansion of section 35(2)(c)(1) by adding additional words, including a particular reference to intimate images, that is, whether that section should be expanded by the addition of those words. It also asks whether protection from cross-examination should be extended to vulnerable witnesses beyond a child, as is currently proposed in section 41(A). It is also interested in clarification in relation to section 48(4)(a), and which children that includes. It also seeks the deletion of section 50, subsection 4, subsection C, concerning family law court orders, and inquires as to whether the Attorney-General would agree with that position. The group is concerned about whether 72(c)(1) may also be misused. It is worried about whether there is an imbalance between government and non-government representation, as has been established on the Domestic Violence Death Review Team, as is proposed in the review and in this bill. In relation to the team, it also argues that there should be a legislative requirement for government to respond to team recommendations in a timely manner, which strikes the opposition as a very sensible proposal. We seek the response of the government to the issues raised by Women's Legal Services New South Wales. Having said that, with the exception of the issue about reporting by the team, the opposition supports the legislation.
Order for the